Morning, everybody. Thank you for joining us for today's webinar. My name is Amber Hines, and I'm the owner of AshBer, where we specialize in Medicaid-compliant annuities. We are super excited to have attorney Todd Whatley with us today. Todd's going to be talking about the difference in estate planning and elder law and the differences between the two. If you have questions on today's session, feel free to type those into the questions tab of the GoToWebinar dashboard. And also you can find a copy of the slides on the GoToWebinar dashboard as well. And with that, Todd, I'll go ahead and hand the presentation off to you.
Cool. Thanks, Amber. I appreciate it and I always enjoy working with you and your folks. And so, uh-oh, wait a second. That's not what I wanted to happen, I don't think.
I can still see it on, yeah, I can still see your slides.
Okay, good. Okay. All right. So this is one of the issues, I do a lot of coaching with people across the country. And one of the issues is we get estate planning attorneys and they're like, well, I kind of do elder law because I work with older people. And I'm like, yeah, but do you really? Okay. There are some very substantial issues that differentiate estate planning attorneys from elder law attorneys. And that's what I want to talk about today. Okay, so why is there a difference? Choosing the right approach ensures that a client's wealth is not only transferred, but truly protected, all right? And that's where we come in. I always like to tell people, and I'll say this quite a few times throughout the presentation today, is that estate planning attorneys make sure what you have goes where you want it to go. But without looking at this from an elder law standpoint, your client may not have anything at the time of death. And so we are not only ensuring that their wealth goes where it should go, but making sure it's truly protected. And that's where elder law attorneys come in to make sure that the assets are there and they're not wasted or consumed by the things that elder law attorneys are concerned about. All right. Estate planning is about what happens when you die. Elder law is about what happens if you don't. Okay. And that's kind of a crass way to say it. And I had clients in yesterday going through this, and this lady was in a marriage where she married someone 17 years older than her. And they've been married quite a few years and they had a lot of good years, but then things started going bad. And she said, I never dreamed that he wouldn't just pass away. She said, where we are now, and he's needing nursing home care. He's had a few surgeries, not done well. He's having a lot of help is needed. And she was just like, I never dreamed that I would have to go through this. And this is things you don't think about. And I was like, yeah, that's it, exactly it. So when does this come into play? When should you start, looking at a client, not just for estate planning, but looking at it from a true elder law standpoint? Age is one way to go, and we'll discuss different ages, different things. But as people get older, okay, you will find people that are in all these age groups in all different functional situations. This has been kind of a rough week for me. A good friend of mine, my first employee in my law office, she was 2 years older than me. We were good friends growing up. She had a liver transplant and she was pretty much over it, but could not work full time. She wanted a part-time job. I needed part-time help. And so she was my first employee. And now 27 years later, she passed away this week and spent about 2 weeks really down. She was on hospice. And so you will see people that are in their 60s that are pretty decrepit, and you'll see people in their 60s who are still functioning and going. I turned 60 this year and I run 2 to 3 miles 2 or 3 times a week. And, I'm up and going and I don't need help. But you will see people my age who need a lot of help. And you'll see 80-year-olds, 85, 90-year-olds who are doing pretty well. They're up and going and doing and, still working around the house or the farm or whatever. So it's not strictly age, but age can be a clue, but function and risk are the real triggers. Okay. And so when you're doing a meeting with a potential client and they start talking about estate planning, it's like, when I die, this and that. Well, inquire as to how they're doing today. Tell me how your day goes. Do you need help? Do you need, have you had any significant diagnoses lately? And so it's, age is a clue, but function is the real thing. So what do attorneys miss? Okay. So many estate planning attorneys, as they should, focus on death. Many plans only address what happens at death. I see a lot of estate plans come through my office. People are like, hey, would you look at this? And I look at the trust and their will, and I'm like, where's your power of attorney? They're like, oh, we didn't do a POA. And I was like, wait, what? You did not do a power of attorney? They're like, no, doesn't that die when you die? And I'm like, yeah. And they're like, well, this is for my death. I'm like, oh my Lord. Okay. There were so many things that can happen between today and the day that you die. And many times that includes dementia, incapacity, things like that. And you absolutely have to have a power of attorney. But if you are just strictly focused on death, yeah, trust, wills, that's what matters. But the greater risk is decline. Most families face greater threat from incapacity, long-term care costs, and asset erosion. That's the real problem here. And this is why elder law is such a growing profession, in that our healthcare system is doing a great job of not letting people die, but it's not doing a great job of helping people have a good life. Okay. And it's that declining capacity, declining physical status that concerns a lot of families. And when they go to an estate planning attorney, they're expecting, and the attorney tells them, okay, when you die, here's what happens. But we as elder law attorneys are like, yeah, that's the easy part. We can fix that. If you have something, here's where it goes. But what about incapacity? What about your new diagnosis of Alzheimer's? You know that's going to get worse. Let's talk about that. All right. And so estate versus elder law is: estate planning transfers wealth. Elder law protects it while you're alive. And like I like to say, it makes sure that there is something to pass on to the kids. Okay. Without elder law planning, you can easily lose everything. So again, estate planning focuses on distributing assets at death and avoiding probate. Okay. Most estate planning attorneys avoid probate. I know some states probate's not a big deal, but many times it's still easier to avoid probate and make things go quickly. Elder law prioritizes protection during life: incapacity, Medicaid, care cost, who's going to care for mom and dad, and particularly when one spouse passes away, who's going to help. Those are the issues that we're dealing with all the time, a lot of family issues. Okay. Each profession takes a different view of risk. Okay. The risk with estate planning, we don't go through probate. We don't want to waste that money. We want to make sure your stuff goes where you want it to go. The risk for elder law attorneys is, how do we not lose everything? Okay. So key differences at a glance: estate planning, distribution, probate avoidance, simple incapacity docs. And so many times I've got a good friend who just does estate planning, and I've seen some of his people come to me once they need long-term care, and he is adamant that he does a springing power of attorney. And if you're doing a springing power of attorney, I'm not saying that you're wrong, but I'm saying here's what happens: is to spring that document to get it to be effective sometimes is a very contested issue. If the person refuses to go to the doctor and get the letter saying that the agent can now do something, we can have this beautiful power of attorney, but it has absolutely no effect, and it won't have effect until the person goes to the doctor. And if they refuse to go to the doctor, that's a problem. And I've told him this repeatedly. I'm like, it would really help me out if you did not do springing POAs. Have your person pick a trustworthy person and give them the power now, so we don't have to jump through those hoops to get this thing in place. He's like, well, clients just don't like it. I said, I know they don't like it, but if you explain to them the downside to it and the possibility that we may still end up in guardianship court because the person won't go to the doctor and there's things that have to be done and we can't do it till this person goes to the doctor. And if they don't, we end up in court. And that's the whole purpose of our documents, is to prevent these people from going to court. And so, there's that mindset of, well, this is how we're going to do it. But hopefully I'm convincing you as an estate planning attorney to do things a little bit differently, or giving you some keys to talk to your estate planning friends and say, hey, when your clients come to see me for nursing home care, here's what I would love to see. Okay. So again, elder law focuses on incapacity, care expenses, Medicaid, asset protection, successors. Okay. Many times our clients are owed and their agent could be their spouse, they pass away. And how many times have you seen someone bring in their online, they did it for $75, did their documents online, and they're like, power of attorney, spouse. Okay, next. Okay, well, that's great that you named your spouse. When your spouse dies, if there is no successor, we end up in court. Okay, you did this document hoping to stay out of court, but because this document does not have a successor, they're in court. Or they're like, okay, maybe spouse, one kid. Okay, but God forbid, what if that one kid passed away? My good friend, 62 years old, just boom, died. And out of her siblings, she is the best one. And I did her mom's documents naming her, but we did name a backup. And the mom was like, well, these other two aren't very good. I know, but if Lydia's not here, then we need to name someone else. And we did name a backup, even though they weren't ideal, but it's better than nothing. And today we are glad that that happened, because since the daughter's gone, we now go back to the successor. We don't have to go to court. Essentials. Okay. The essential documents that estate planners are looking at: wills, beneficiary forms, typically simple trust to focus on distributing and avoiding probate. That's what estate planning attorneys do. Elder law attorneys, okay, we are looking at Medicaid planning. We need a power of attorney that has extensive language giving the agent the power to do whatever needs to be done, including gifting, closing bank accounts, transferring accounts, doing whatever. Okay. Asset protection, moving assets, gifting is the key thing here. Advanced directives, what do these people want when they're laying on their deathbed? Do they want CPR? Do they want a respirator? Do they don't want surgery and blood and all of this stuff, feeding tubes, IVs, things like that? People are very concerned about this, and they may or may not bring it up to you, because again, if they're thinking, okay, I'm coming to this attorney for when I die, we are only talking about from death on. But as elder law attorneys, it's like, hey, we're talking about from today until the day you die. We can take care of things after you die, but from today until you die, in those last few days, can be very tenuous, shall we say, because some family may agree with your decisions not to seek treatment. Other families may agree. We want to take that out of their hands and put it in this document so that it tells the world, here's what you want. And clients appreciate that greatly. Okay, so that's your advanced directives, which are part of the documents that we do for people. And then caregiver backup. Okay, sure, you want this person to do it, but what if? What if they haven't done it? And so many people never think about that. They're like, I never thought about my daughter dying first. Okay, and so it is our job to bring this up to them. So again, our way that we as elder law attorneys and estate planning attorneys look at risk is different. Estate planners assume high function until death. Okay, you're fine and dandy and you die, and some people do that. It's not very often, but some people do that. We as elder law attorneys, we plan and expect this person's going to decline, and we plan for it. One statistic that I've seen consistently play out is well in excess of 90% of everyone is going to spend some time incapacitated in a medical facility. Okay, that could be a hospital, hospice, assisted living, nursing home, something, but you're going to spend some time, it could just be hours, but it could be years that you're going to be incapacitated toward the end of your life. And if we don't plan on that, that's a problem. Okay. So here's the three age bands that I kind of, as a general rule, again, you will see people not in their appropriate age band, but typically from 40 to 60. In my office, those are young folks. Okay. Those are the young people. That is typically your standard estate planning. Okay. They're not concerned about long-term care. They're very healthy. They're up and going. Things are fine. I don't want to talk about it, but we do a standard estate plan, and it always includes the Medicaid gifting, things like that. Okay, I say always. If the client, typically you're 40-year-old, there can be a lot of difference between a 40-year-old and a 60-year-old. Sometimes 40-year-olds still have younger children. 60-year-olds typically don't have kids in the home anymore. And so there can be some difference, and you have to play with that. But then we get to the 60 to 80. Those are the people that are seeing a decline. They've had friends who have died just like me. My 62-year-old friend passed away, and it wakes you up one day and it's like, oh shoot, okay, I'm now 60 and pushing 80, and I can see things are going to be a problem, and there are enhanced issues there that we need to take into consideration: health, care costs, and new planning needs. But between 60 and 80, surely your kids are grown and they're off. And when they did the estate plan, you know, 20, 30, 40 years ago, the kids were young. They had all this language in there for who's going to raise the kids, and, all of this language about when they get their money or whatever. Well, now they're grown and probably totally different people. Their estate plan needs to be different, but then include with that all of the issues regarding long-term care, incapacity, things like that. And then once you get typically 80 plus, that is truly the elder law lane. That's immediate care. We are looking at, probably there's a diagnosis that's going to lead to a need for enhanced care, be it at home, assisted living, nursing home. Something's going on that this person's going to need more care, and we can see incapacity is upon us or is quickly coming. And that's where we as elder law attorneys really can address the family's issue of, like, mom's 84, 85, 90, we need help. Okay. And that's where we come in. All right, function and risk, how to spot triggers. And these are things that you're going to have to bring up in a meeting. Sometimes people come in with it and they're like, here's why I'm here. Mom's bad. There's issues. But a lot of times old people avoid this. They will cover up. And I've seen couples that have dementia and can cover for each other, and the family has absolutely no idea, particularly if they don't visit in person a lot. It is amazing how they can cover for themselves or for each other in a 10, 15, 20, 30-minute phone call. And it's not until you're there and you spend extended lengths of time with this person that you're like, oh my goodness, they have some issues going on. And that's why during the holidays, I always put out podcasts and YouTube and interviews on TV, whatever, saying the holidays are the perfect time for you kids to get into mom and dad's house, be a little bit nosy, and see what's going on. Look for signs, look for triggers that are going on. So look for a decline in function or independence. You'll see maybe if their bedroom is upstairs, they're now sleeping on the couch or sleeping in the recliner all the time. Okay. That's because they can't get upstairs. Very good sign that they don't need to be in that house anymore. Look for signs of, issues. Is there a cane? Is there a walker that you did not notice lately? Do they wear the same clothes many days in a row? Has it been a while since they took a bath because they can't get into the bath or they're scared of falling in the shower? You don't catch those on the phone. Okay. You've got to be there in person to see what's going on and physically lay your eyes on them and for some time to see what's going on. Cognitive changes, memory issues. Again, they can cover that very well in a 30-minute phone call. But when their short-term memory is an hour or less than an hour, you won't catch that on the phone call. But when you spend time with them, it's like, I answered the question about where we were eating dinner an hour ago, and she's asking me again, hey, where are we eating dinner? It's like, Mom, I just told you that. And so that's where you'll spend some time with people and see there's some cognitive issues going on. And then many times urgent care needs. Okay. And again, people come to you as an attorney thinking you're going to do one thing. And if you're doing estate planning, they're thinking documents, when I die, blah, blah, blah. And they may not bring up because you're an attorney, you don't deal with home care issues. You don't deal with mom being unable to dress herself anymore. That's not your function. Okay. But as an elder law attorney, it is our function. That is our job, is to figure this out, ask those questions and see what's going on and delve into their personal and their physical and their financial life to say, hey, you may think that you're just here for trust, maybe POAs, but let's talk about this. And almost always they're like, oh, thank God you're the person I can talk to. They don't know who to talk to unless they call a social worker or talk to their doctor, and their doctor spends about 3 minutes with them. He or she's not going to talk about that. And to finally find someone who can answer these questions and has an insight as to what's going on, they are very happy. Don't think that you're intruding. And sometimes they will. They're like, yeah, I don't talk about that. Okay, fine. But just know that's what I deal with. And the client may not want to talk about it, but the kids will. All right. All right. You cannot predict the future, but you can make a plan that stands firm when it arrives. And this is what I love to tell people. They're like, but I'm not concerned about that right now. And that, honestly, not many people say that, because generally, if they're in that 60 to 80 range, they have either been through it or they know someone who's been through it. And when they see a close friend go through it, they become very, it's like, we need to get something done. Okay. I don't want to go through that with them. Or their friend's parent died and everything went through probate, and they finally got their money after fighting with their siblings and fighting with the bank and all of this stuff's going on, and they're like, we don't want to go through this. And so providing a plan that stands up when these things happen is invaluable. So here's some things to um, look for. Okay, kind of function filters, and a lot of this deals with function. Again, you can be 60 and in great shape, like I think I am, or you can be 60 and on death's doorstep. Okay, you can be 80 and be in really good shape, or you can be 80 and not. What you need to look for is who's helping these people, and what help do they need. Reminders for meds. Okay, when these people, particularly with dementia, don't take their medicine, they get really out of shape. Okay. And many times with blood pressure and different things going on, if they don't take their medicine consistently like they're supposed to, their health is going to decline significantly. I've had clients who had to put a loved one into the nursing home just because they weren't doing well, just generally not doing well. And when they got them to the nursing home, and the nursing home, by law, and their job is to make sure this person gets their meds, when they started getting consistent medication as it was prescribed to give, these people get tremendously better. And I've seen some even leave the nursing home with everyone knowing, we've got to make sure mom takes her meds, because this whole decline was purely because she was not taking her medicine. And so now let's spend, a few $100s a week to get someone in there to make sure mom takes her medicine. She can do fine at home, but it's purely because of medicine. And so I would bring this up, make sure, someone in the family answers the question, are you taking your meds correctly? And if you don't remember how to do that, who helps you do that? Okay. Look at the bills, look at the driving. I always tell people in my Christmas, Thanksgiving shows, I always tell the kids, look at the car, go out and make a round around the car, look at the car, see if there's some bumps, scratches, things like that. Because as people get older, they can't move as well to look behind them. They don't see as well. They don't hear as well. And they start bumping into things with their car. And hopefully it's just a bump and not a, oh my God, car wreck. Okay. So I always tell people, look at the cars, be a little bit nosy, go through their desk, go through their, where they put their mail and see, do you see bills that are not being paid? How are they physically? Are they clean? Do they smell? Are they wearing the same clothes? Are their clothes washed? Those are things that you don't want to think about your parents or your loved one, but it's so important. It's a filter to say this person needs our help very quickly. Okay. And then again, the telephone, you can't tell how independent your loved one is. When you start spending time with them, you'll see, oh my goodness. And we've a lot of years, we've had a significant increase in business right after the holidays because people come in, see how bad mom and dad are. They had no clue because it was just phone calls, and they come in and visit and they're like, we need to see you immediately. Mom and dad are not doing well. We had no idea. Okay. So what tools do you need? You absolutely need POAs. My associate did a meeting yesterday. The lady came in for estate planning primarily, and we always talk about trust and POAs because that's what we do as elder law attorneys. Is I tell people every day, the most important document you can do is a power of attorney. Not a will, not a trust, pretty much not anything. A power of attorney is the most important document you can do. And we rarely get pushback from that. But she was telling me, she said, Todd, this lady, we talked about a trust, and then I just naturally moved on to powers of attorney. She said, oh, no. I didn't come here for that. So wait. Why? She's like, well, I'm just worried about my trust. I don't want to talk about POA. And you're like, wait a second. You have to have a POA because that's the other court that you don't want to go through. And I think she kind of just was like, no, I don't want to talk about it. And she said, Todd, that's the first time I've had someone just absolutely tell me I don't want to talk about this. I said, well, that is pretty bizarre. Most people are very happy to know, oh, there is guardianship court. And if you can keep me out of guardianship court with this document, yeah, let's do it. So obviously make it durable, make it immediately effective, and make sure it's very comprehensive and has all of the language in there for the agent to do whatever. Healthcare power of attorney, directives, HIPAA forms, okay? You have to give people HIPAA releases so that their agent can get the documents. Just because someone has healthcare power of attorney or financial power of attorney does not give them access to their healthcare documents. You have to sign a HIPAA form. Now, most people, if they're conscious and can do it, when they go into the hospital, they will sign their HIPAA form. But what if the person goes into the hospital unconscious and they can't sign HIPAA forms at that facility? Family comes in, it's like, tell us what's going on. They're like, sorry, we can't because we don't have a HIPAA release. You have to have a release. Okay. Trust are important. Okay. We use trust for probate avoidance. Those are extremely common. I do a whole presentation. I encourage you to go listen to my podcast, the Elder Law Coach podcast. I think it's becoming my most listened to podcast is when to and when not to use a Medicaid asset protection trust. So many times in my coaching clients, they know very little about elder law. They get into it and they're like, oh, there's this trust that can protect assets from Medicaid. I'm like, yes. And they're like, oh, great. I'm going to sell this to everyone. I'm like, no. You can't sell it to everyone. It's not for everyone. It's for specific people. So yes, there are asset protection trusts when needed. Okay. And then one thing that people don't think about is backup agents. Plan for agent burnout or death or incapacity, because many times they're appointing someone close to their age and that person can burn out, don't not want to do it anymore. Great, there's a backup. Or they pass away. Great, there's a backup. These may surprise you, and I think this is very conservative because in Arkansas right now, which tends to be cheaper than most states, nursing homes are $9,000 a month. Well, 10,000 a month is $120,000 a year. So do the math. I think most nursing homes are over 100,000 a year and probably pushing about 150,000. And even assisted living is expensive. It's 5, 6, 7, 8,000 bucks a month. These are some major expenses that can cause major issues with people's estates. Now, what are the coverage gaps? People think, okay, good, I have Medicare, Medicare pays for the nursing home. Yes, Medicare pays for the nursing home for about 20 days, maybe 100 days, and then that's it. They're done. So Medicare is there, but it doesn't cover what people think it thinks it covers. You can go to the nursing home under Medicare, but you're not going to be there long under Medicare. Um, Long-term care, okay, it is either private pay, insurance, or Medicaid. Someone's writing a check out of their checking account each month to pay for it at 9, 10, 12,000 bucks a month. Very few people have insurance, and then there's Medicaid. Okay. The VA aid in attendance is there many times to help. It has a capped benefit. You can only get a limited number of dollars, and it's in the $2,000 to $3,000 range. That doesn't pay for the nursing home. If someone doesn't have enough income to go with the VA to pay for the nursing home, they've still got to go on Medicaid. And when you go on Medicaid, VA drops out. So there's a lot of times people come to me and they're like, hey, dad needs nursing home. Thank goodness he's a vet. He qualifies for aid in attendance. I'm like, okay, but we still have to do Medicaid. Why? Well, the nursing home's 10,000 bucks a month. Your dad makes $2,500 a month from Social Security, and all the VA is going to pay is about 2,500. So we're up to 5,000. Where's the other 5,000 coming from? Oh yeah, we need Medicaid. All right, who goes where? Okay, so the standard estate planning track is strong function, good cognition, and there's no care on the horizon. Okay, those people, sure, estate planning, but I still encourage you to put some language into the POA that helps us with long-term care. The elder law lane is like, okay, this person absolutely is in the elder law lane. They need caregivers. They have memory concerns. They have fallen. Their spouse is very fragile, and they have assets that are at risk that we need to protect. So, example A, this lady's 52, strong capacity. So we want to coordinate benefits, make sure that things are there. This is a great age to talk about long-term care insurance. And I would encourage you, if you have someone nearby that is good at long-term care insurance, get them involved. If not, I sell it, AshBer sells it. We can definitely talk about long-term care insurance and help your clients get what they need. Absolutely, POA healthcare documents need to be done. And then the standard estate planning, avoid probate. Okay. Sometimes that's a trust, sometimes it's not, but you don't want to go through probate. But there is no current care risk. So they're like, yeah, this is great. Okay. Example B, they're age 77, 86, they're getting on up there. There is a caregiver involved. They've had recent falls. They have documents that don't quite do what needs to be done, stressed documents. Asset protection is vital. They have assets that the other spouse needs to live off of, or that they really want to give to the kids or whatever. That's where the elder law framework becoming engaged and can help these people. So, emergency plan. How do you deal with this? Number one, age. Okay. Age is important. It's not the final determinant, but it kind of gets you thinking in certain lanes. But then once you get them in and think function, okay, how are you functioning? What's going on with your day? Do you need help through your day? That helps finalize and say, okay, you're going down this track. These are the things that you absolutely need to do. So early, durable planning ensures real protection for every family. I always tell people, hey, there's some cool things I can do in a crisis with elder law, rules, understanding Medicaid, VA, different things. There's some cool things I can do in a crisis. But if we can do some planning not in a crisis, I can protect way more money. I can make things a whole lot easier for you if we can plan ahead and not have to be in crisis mode. Because in crisis mode, it's like they're in the nursing home or they are headed there and they see this 9, 10, 11, $12,000 a month bill coming in. And it's like, oh God, what do we do? And so we can do some cool things in emergencies, but pre-planning is always better. All right. So I am Todd Whatley. If you want to do an in-depth estate planning versus elder law, I am doing through my coaching program, I am doing a weekend estate planning, which will involve pre-planning for Medicaid, have some things there. That is June 12th, 13th, and 14th. Yes, that's all day Friday, all day Saturday, half a day Sunday. And we will go into depth on every type of trust we use in elder law. We will talk about powers of attorney, end of life documents, things like that. So go to theelderlawcoach.com. That's my website if you're interested. And I would love to see you come to beautiful Bentonville, Arkansas. It's beautiful. It's cool. It's not crowded. Well, it's getting there because everybody's coming. But anyway, if you need me, Todd at the Elder Law Coach. Also include Tricia because I am not the best at emails. But email Tricia. She'll make sure that I see it, make sure she gets it on my calendar, and I will discuss this with you. Okay? Questions?
Thank you, Todd. We do have a couple of questions here. We have one about how do you recommend handling the situation of a trust that requires incapacity determination for the successor to take over? Would you recommend a disability panel instead, or naming a child as a co-trustee if there is one?
Okay, great question. So when I first started this, the typical way to determine that the current trustee can no longer do this is to get a doctor or two doctors. Again, like with the springing POA, that can cause problems. If the person refuses to go to the doctor, then we're stuck. What I do now, and this was developed over years of trial and error doing this, here's what I do. And I explain this to my clients so that they agree to it and we put it in their trust. And I call this a bloodless coup. Okay. It's a way to take over without having to go to the doctor or to court. And that language says once the successor trustee thinks that the current trustee is incapacitated and can no longer function, then that successor trustee makes that known to the trustee, typically by calling me as the attorney. And the successor trustee may not read that in the trust. It just naturally happens because they know I'm mom and dad's attorney, and they call me and say, Todd, mom's hooked up in this romance scam, or she's, she or he are doing crazy things. They're not managing their money very well. I need to step in and take over. What do I do? And I tell them, you just did it. And they're like, did what? I said, well, their trust says once you make that known, then I will call my clients and say, hey, remember your trust says if the successor trustee thinks you're no longer able to handle your affairs, you now have 30 days to either go to the doctor and prove that you're not incapacitated, or if you refuse to go to the doctor, 30 days from now, you're out and the successor trustee is in. So you see how that they don't have to go to the doctor. If they refuse to go to the doctor, fine. 30 days from now, the trustee steps in and they're out, or they do go to the doctor. And I have never had one of these cases occur when the child called me too early. typically they're about a year too late. They're like, hey, Todd, we've been dealing with this for a year. Finally, we just decided to call you. I was like, okay, you're a year later than you should have been, but here's what we'll do. And so I call my client, hey, Miss Green, your child thinks you're not managing your affairs. Well, I'm doing perfectly fine. I said, I know. I am not involved, but I take your word for it. But if you remember, your trust says once this claim is made, you have to go to the doctor. Well, I'm not going to the doctor. I said, okay, that's fine. You don't have to, but I'm telling you, if you don't go to the doctor, 30 days from now, your son's stepping in and taking over. No, he can't do that. I said, yes, ma'am. We discussed this when we signed your trust. You agreed to this. And she's like, well, and I said, well, go to the doctor and prove you're not incapacitated. Bring me that letter. And if that letter says that, I will tell your son to back off. That never happens. Okay. So eventually either they go and the doctor's like, yep, you have dementia. You should not be doing this. Or they just simply don't go. Either way, 30 days from now, the successor trustee is in place, and it's outside of court, outside of bringing in a disability panel and all of that. It's just very quick and easy.
Okay, perfect. We have another question here about, can you briefly explain how you deal with people in their mid-60s that are healthy, that come in and say they want to protect their assets from a nursing home, but when we try to explain that they will no longer own the assets because they'll be in a Medicaid asset protection trust, they opt to not go that route?
You just don't go that route. Okay. I mean, it's one or the other. Okay. People think, yes, I would love to protect my assets. That's a great goal. But the way to get there, yeah, I'm not a fan of that. Okay. Our job is to explain this to them. It's their job to tell us what to do. And so I will tell you, I don't do many of those trusts. Okay. That's why coaching clients are so excited. Oh, yes. And I charge a lot of money. I charge basically 1 month's worth of nursing home costs, which right now is $8,500. So I charge $8,500 to do this trust. And that makes them think about it. The second thing that I do that I would highly encourage, because once, I've made pretty much every mistake you can make in elder law, and I've learned from those. And now I teach my coaching clients, here's what you should think about. So today, when I present an asset protection trust, and they know both of those things, you won't control it and you won't benefit from it. Do you still want to do it? Yes, absolutely. Okay, well, you need to think on this for 2 weeks. So I'm going to schedule you for 2 weeks. You sleep on it for 2 weeks, come back in 2 weeks, we'll sit down and talk. And if you're still gung-ho and you want to do it, then I'm going to get half of my fee up front. I'm going to do the trust, and then you'll pay the other half when we sign. But so many times, I mean, there were a number of times people were like, yeah, let's do it. And I'm like, great, pay me your money. I get to work on it. And then a week or two, they talk to their financial advisor. They talk to their kids, someone, and they're like, Mr. Whatley, I changed my mind. I don't want to do that anymore. I'm like, well, you paid me half and I've earned that. I've done your trust. They're like, well, I'm not signing it, so I want all my money back. And then you're in this fight with your clients, like, hey, I've done the work, well, but I didn't get a trust out of it, so I want my money. So it just causes problems. And yes, you will lose some clients, but if you do the 85, it is $8,500, come back in 2 weeks, and they're still on board with it, I think you can easily say, I gave you 2 weeks to change your mind on this, get your money back. No, I am not refunding your money. And I think we can argue to a board, an ethics board, after there's been a complaint, to say, I told them on this date, I gave them 2 weeks to think about it. They still 2 weeks later wanted to do it. They paid me half. I did the work and I'm not refunding their money. And they're like, yeah, we understand that. So I don't do many of these because I am super cautious about it. It's a big step. If you think about it, this is a person's life savings, and they are putting everything that they have spent their entire life working on, and you don't put everything in the trust, but figuratively speaking, a large amount of assets are going into this trust, and it's gone. They can't control it. They can't get it back. They don't benefit from it other than living in the home. But it's a big step. And I would rather lose 9 clients out of 10 presentations, but do the one and know that it works and have 0 issues from it.
Okay, what percentage of your clients are general estate planning clients versus elder law clients?
Okay, number wise, it's probably 90-10. Okay, we do, Lauren, my associate, all she does is estate planning. She knows a little bit about Medicaid, but I am the Medicaid person. But we do a lot of advertising. We do a ton of marketing for estate planning, but that gets them in the door. They learn about us, they like us, they trust us, and then those people are the ones who come back later on when they need Medicaid. Okay, and sometimes we just lose them because they don't need Medicaid, they just pass away. But I would say, looking at the number of clients on our schedule, it's 90% estate planning, 10% Medicaid.
Okay. For clients that have significant traditional IRA assets, say over $1 million, how does that impact your recommendations for long-term care or 5-year planning with these clients?
I hate those clients. I mean, not those clients. I hate those facts. But yes, that happens. And those people, you can't help much because, even if you did the annuity, I mean, with the Medicaid rules currently, the community spouse can only have $160,000 basically. So you've got to get $840,000 into an annuity that's going to be paying out over not that long of time. And every dollar from that's going to be income. That's going to throw them into a very substantial tax bracket. And to be honest, I tell those people, you've done very well in life and you did not pay many income tax so that you could set back this $1 million. But at this point, there is not much I can do for you because you can't put those IRAs into the irrevocable trust without a taxable hit. It's hard to put it into the Medicaid qualifying annuity unless she's 60 and he's 80 in the nursing home. Yeah, you've got quite a few years there, but those are just tough cases. I mean, and there is not a good solution for them. But
It looks like
those are great long-term care insurance clients.
Yeah, it looks like here this attorney was asking about a 5-year plan. So I guess if there was traditional IRA assets and they were healthy enough to qualify for like a hybrid long-term care policy, you could consider that
yes.
Or another type of annuity vehicle that has a long-term care rider on it would be my only other recommendation on that.
Yeah, those are great long-term care insurance clients.
Okay. Perfect. I am not seeing any other questions here. Somebody was asking about long-term care insurance products, but I can reach out separately about that and send some information. So I think that we are good to go, Todd. Thank you for your time today. Thank you, everybody, for joining us, and look for our March webinar information shortly.
Thanks, Amber. Y'all have a great day. See you.
You too. Bye-bye.